The news these days is nothing but scary headlines about court cases and can very much ruin your post-weekend vibe. So let's dive into what the news actually means. Start this week out right, shall we? Happy Monday, everybody. I'm Brian, and this is the first fall morning report on the federal courts for September 21st, 2025. Double tap your screen. Leave me a comment whether this was a summer weekend for you or a fall weekend and what you did, and try to watch at least through the intro so we can hit the FYP. Check out brianodc.com for some cool stuff, including mugs and my awesome new fall ducky t-shirt, so we can try to keep this sustainable. All right, everybody strapped in? Let's get to the news. All right, we're going to start with Pacito v. Trump, and this is a case about refugees. So we're going to start trying to define the word refugee for a minute, but it's a word that's used really inconsistently, so it's a little hard to pin down. I'm going to start by defining a few other words that are a little bit easier. We'll try to figure out what refugee means. All right, I'm going to start with immigrants and non-immigrants. Non-immigrants come to the U.S. to visit, to see family, to work for a bit, go to school, but then they leave. Immigrants enter this country intending to stay from day one. Now, a non-immigrant can change their mind, decide they want to stay, but when they cross the border into the U.S., the plan was for them to leave at the end. Okay, immigrants, non-immigrants. Next, internally displaced people, or IDPs if you work at the State Department, have been driven from their homes, but they're still in their own countries. Maybe there was a fire, maybe there was a political issue, but they're still in their own country. They're just sort of unmoored within that country, and by definition, they're homeless. Okay, sometimes people will call internally displaced people refugees, even before they decide it's time to get out of wherever they are. But in the context of U.S. immigration law, if we're talking about refugees, we mostly mean people who probably started off as internally displaced, but now they're trying to move to the U.S. So we usually distinguish between immigrants and refugees because immigrants come here because they actually want to. Maybe they got a new job here, maybe they married an American. Refugees come here because they have nowhere else to go. That make sense? Okay, now some refugees are currently in another country. Maybe their home country, maybe they've had to flee to a third country, but they're asking to enter the US as refugees. Think a boat full of German refugees in the 1940s, but the boat is still in Europe, still docked. Others either are at our border or even inside our border and asking to be allowed to stay. Sometimes these are called offshore refugees versus onshore refugees. But I'd say a little more commonly, they are separated into refugees, people outside of the country, and asylum seekers, people who are already here. So, understand the terms refugee, asylum, immigrant, internally displaced person can overlap a lot. But at least you have some sort of context when you hear these words and some sort of sense about how they might be different now, right? Okay, now we're going to get to the case. Pacito. This case is really messy. So back in January, President Trump issued an executive order basically blocked all refugees from entering the country. And a big part of this case, from what I can tell, is which of two parts of the refugee law govern his power to do that. See, there's one part about how many refugees are allowed into the U.S. every year. And the president gets to set that number, but he has to consult with Congress first, which he didn't really do. But then there's another part of the same law that says the president can deem entry of a class of aliens as detrimental to the interests of the country and just bar them from entry. And that's what he did, but he did it for everybody in the world, basically. And then he also canceled all of the contracts that took care of refugees while they're waiting to enter and once they come into the country. So this case is brought by people who had already been accepted as refugees by the time he said that but weren't here in the country yet, and also by the contractors who were taking care of those refugees. So, no decisions have been made in this case. It's all preliminary stuff, injunctions, stays, things like that. But the Ninth Circuit Court of Appeals did say a couple of important things last week. First, based on the president's authority to ban groups of refugees, they blocked the preliminary injunction from the lower court that allowed people to enter in the meantime. So people who are stuck outside of the country waiting for an answer are still stuck. They're going to have to wait for now. But they also said the law that keeps those contracts in place taking care of refugees, particularly unaccompanied minors, have to be kept in place. And 8 months ago, when the administration canceled these contracts, they told the court they were just looking for new contractors. But 8 months later, they still haven't replaced them, and the Ninth Circuit said, no. You guys don't get to just waffle forever and leave unaccompanied minors hanging out to dry. So the contracts are all reinstated, but we have to wait for an actual decision to the court before we know what happens to the refugees. So that's where we are in Pacito. Okay, now we're going to take a look at DOD v. AFL CIO, and you're going to notice this is one of those rare cases where the government is named first because they're the ones suing the AFL CIO. So back in July, their suit was dismissed, and here's why. The plaintiffs are 8 federal agencies that wanted a declaratory judgment authorizing them to terminate collective bargaining agreements, union contracts, through an executive order. But what they didn't do is say, hey, court, we have been injured by these collective bargaining agreements, which we shouldn't have to abide by, or any of the other ways that somebody generally brings an argument in front of the court. See, the one thing the court is not allowed to do is issue what's called an advisory opinion, a theoretical opinion about what it thinks the law probably is. It's only allowed to look at an actual set of facts that demonstrate some sort of real injury and then adjudicate whether that injury violates a law or is the basis for a financial recovery, something like that. But that's not what the government wanted here. What they wanted was the court to say, hey, executive branch, you're allowed in general, in theory, to do this thing. But that's not what the court does. The court only looks at actual, real situations. So the court said, no, cannot do this, and dismissed the case. Normally, if your case gets dismissed, you can only appeal it for 30 days. But the rules of civil procedure allow the federal court the federal government 60 days to appeal. So that 60 days would have ended on Wednesday, and the feds got in just in time, so they've appealed this motion to dismiss. But I'd say they have a pretty limited chance of winning on this one. They're just not presenting an actual question to the court, and that is really key. It's really fundamental. I mean, granted, this is Texas, it's the Fifth Circuit. If anybody's going to find a right of the executive branch to do something, it'll be them, but I would be surprised. However, I have also been wrong before. All right, next, a judge in California issued a temporary restraining order last week blocking the federal government from withholding funding from states that refuse to provide the personal information of people who receive SNAP or food stamp benefits because they want to use it to track immigrants. The court said basically 2 things. First, there are both federal and state laws in place that prohibit states from sharing this information, except in really limited circumstances, and this is not one of them. So by withholding this information, the states are actually just complying with the laws that Congress wrote as a prerequisite for giving them this funding to begin with. Second, the USDA, who issues this funding, also has its own very clear set of regulations about how this information is allowed to be used, and has openly stated in this case that it intends to use it for other purposes. Specifically, it's going to try to use it to track and target immigrants, which it says in its own rules it's not allowed to do. So the court says, guys, I'm just applying your own rules here. You yourselves won't allow you to have this information. It says it right here. So this was almost a done deal. However, apparently, and I'm quoting the judge here, during literally the last minute of the hearing, for the first time, end quote, the USDA threw in some curveballs. So, for example, they asked, how about a preliminary injunction that only allows us to use the information for certain purposes? And since no one had time to research these arguments properly and argue them at that moment, the judge decided to just issue a temporary restraining order for now instead of a full preliminary injunction, which would have lasted longer. So now everybody has to come back for a second round of arguments. There's a TRO in place for now, and they're supposed to submit new briefs next week. I will let you know what happens. All right. That is your first Fall Monday morning report on the past weekend in federal courts. Again, if you can leave a comment or a like to get this out there, I would really appreciate it. Thank you to CompuBear and Ruthie and whoever sent me these off my wish list, because this is the only way I stay hydrated. Otherwise, keep watching and I will keep going. Thanks a lot, everybody, and have a great week.